It's my pleasure now to introduce Professor William Burke-White, whose name in the international law community is fast approaching his famous literary relative. And you do have a famous literary relative.
Photographic relative.
Oh, that's right, photographer.
Unfortunately, she's not related. I wish I could claim she is. We just share a name. But.
Well, I like that. Well, anyway, your name in our academy is approaching that level. It's also funny, about a year ago, there was a U.S. News, or a USA Today article that said as a high school student, Bill and 9 others were profiled by the USA Today as one of 10 future leaders to watch. And they do this every year, and they wanted to like do an anniversary. Where are they now? Our first 10. Interestingly, Bill was profiled for his work in chemistry, and now he's a professor of law at University of Pennsylvania. He's an award-winning author in articles that have nothing to do with chemistry. And he's also worked on accountability issues with the UN and with the governments of Cambodia, East Timor, Rwanda, as well as the International Criminal Court. And we're really happy to have you moderating this panel. Thank you.
So I don't know what it says about USA Today's selection ability if they chose me to be a future chemist, because I don't think I could even get through high school chemistry now. But let me just first of all start by thanking Michael for putting this wonderful day together. I don't know if I've ever been in a forum that had so many of the leading people working on this topic in one auditorium in one day. The one day part is part of the challenge here, so we're going to jump right to it and try to keep this short. I'm going to apologize to my panelists to begin with that I'm going to give the very short form of introduction for them. Not that they don't deserve more, but in order to preserve more time for our conversation. So we have 5 extraordinary panelists who've worked on the questions of prosecuting genocide, most of whom have actually prosecuted, I guess all of whom in a sense have actually prosecuted genocide or decided whether to bring genocide charges. And I will take them in alphabetical order. Immediately to my right is Eric Blinderman. Eric has recently returned from Iraq, where he served as an Associate General Counsel of the Coalition Provisional Authority, and later as Chief Legal Counsel and Associate Deputy to the Regime Crimes Liaison Office, essentially advising the Iraqi Tribunal on the prosecution of Saddam Hussein. He left prior to the execution of the sentence in that case and has now returned to work in a law firm in Washington, I believe. New York, sorry. He's now back in New York. Second is David Crane. You all know David Crane, who was the prosecutor, the chief prosecutor of the Sierra Leone Special Court from 2002 to 2005. He is now the distinguished professor of the practice of law at Syracuse University College of Law, and I have heard David's wonderful stories coming from Sierra Leone, and I hope we get to hear a few of them today. Third, we have Christine Chung. Christine and I actually had the chance to get briefed by Christine at the International Criminal Court, where I was a visiting scholar when she was leading the prosecution in northern Uganda, and she did an extraordinary job bringing indictments there, and then has now left the court, but gives us an extraordinary perspective of how the case in northern Uganda, and to some degree the case in the DR Congo, unfolded, and how those investigations were undertaken. Fourth, I should say, we have Raed Juhi al-Saidi, whose name I know I'm not quite getting right because my Arabic leaves much to be desired. He was the chief investigating judge in the Saddam Hussein case for the Iraqi Tribunal. I assume we're closely with Eric in that process, so we'll get to see both the Iraqi perspective on that and the United States perspective. And let me add to you a warm welcome to the U.S., and we're very glad that you're going to be spending the year in the United States this year. And finally, a man who needs no introduction after the talk he just gave us, Robert Petit, who is the co-chief prosecutor of the extraordinary chambers in the courts in Cambodia for the prosecution of crimes in democratic Kampuchea. I won't say more about him because you've all just heard his talk. What I have asked our panelists to do this afternoon is to speak for only about 5 minutes. I will then throw a series of questions at them and try to get them a little bit riled up in the process, as Melissa was able to do so well in the earlier panel, and then turn the floor back to you for questions to the audience. So taking this alphabetically, Eric, may I start with you for the first set of comments?
Absolutely. And I would just like to thank you for the wonderful introduction and Professor Scharf for putting together this conference. It's an honor to be here, and it's a privilege to be amongst such distinguished guests. As my role as Associate Deputy and Chief Legal Counsel of the Regime Crimes Liaison's Office, I wasn't necessarily prosecuting genocide. It was a slightly different role. We were assisting and advising the entire IHT in all facets of the development and construction of that court, so it would be a credible institution that could function without us. I'm fond of saying is, they stood up, we would stand down. So I come at it maybe from a slightly different perspective than some of my other constituents here, in that I worked with both the investigative judges, like my colleague Judge Juhi, the trial chamber, defense counsel, prosecutors, NGOs, and a myriad other aspects of that court that went to create its establishment and functioning. That said, with regard to the prosecution of genocide, I think in the probably 3 to 4 minutes I have to actually speak, some very important lessons that I think are drawn out from some of the panelists here that I have noticed during my time in Iraq, and specifically on how to put together a case involving such large, sweeping atrocities as genocide typically entails. And first is that distinction. Genocide as a legal matter is separate from a crime against humanity, and it is distinct from a war crime. So from a charging perspective, a lawyer seeking together to put such a case before the bar of justice must focus on not necessarily the scope of the killings. Genocide is not a crime involving mass murder. If you read the case law from the ICTY and ICTR, killing of one or none, even if it involves incitement, when conducted with a requisite intent to destroy in whole or in part a racial, ethnic, or religious group, can constitute genocide. And I think drawing that out from the perspectives of those who are either victimized or participants in the trial, or even the public, is of critical import. Genocide itself is a crime about the individual defendants, what was going on in their mind while they engaged in a series of precipitate acts. Did they have this intent to try and destroy these groups? And as a prosecutor, the most difficult task, whether it be in the documentary evidence you collect, whether it be in the witness statements you collect, whether it be in the forensic evidence you collect, that all must shed light on that difficult mens rea burden. And without meeting that mens rea burden, the ability to charge becomes highly circumspect, and yet oftentimes the public is demanding that mother of all charges to come forward, regardless of what the legal evidence may necessarily show. And that, I found during my time in Iraq, was one of the most difficult conflicts of trying to make sure we had that evidence to demonstrate intent, and balancing that against the desire for either the politicians or victims and others to ensure that that specific crime was charged regardless. But I'm sure we'll talk more about this, and I probably went over 5 minutes, and I'll pass it to my good colleague to the right.
Well, good. Well, thank you. Again, I'm also pleased to be back in Case Western. I'm going to shift this slightly. I'm not going to talk about the substantive aspects of prosecuting genocide. One is that the tragedy in West Africa was not a genocide, but it certainly was a crime against humanity and a war crime. But I would posit to you this point. So what? I'm going to talk to you about a concept that I'm kind of toying around with called semantic indifference. You know, in a war crimes weary world, what we call mass atrocity makes a difference in how it's characterized, because the international community may react possibly to a genocide, but if it's not called that, the world, who is looking elsewhere because something else has happened, such as the invasion of Iraq or what have you, they tend to step over the bodies and move on in the chronology of history. And that was my biggest challenge in West Africa, was the indifference to all that took place, where one saw if you combine Liberia with Sierra Leone, and they're some ways connected, this tragedy over 10 years, the murder, rape, maiming, and mutilation, and you notice I don't say genocide, but the murder, rape, maiming, and mutilation of over 1.2 million human beings. And yet, I'm not sure very many people really pause to consider that. I always say that the lucky ones died, because the horror of the mutilations are beyond description. The concern I have also is the great weight politicians, diplomats, the press give the term genocide, which seems to counterbalance what has taken place in a war-torn part of the world, and that the popular belief is that for some reason if it's not a genocide, then it can't be all that bad. And I'm concerned about that because I saw that in West Africa. As Ben Farron says, a victim doesn't care what we call it academically, philosophically, legally, or what have you. Mass death is mass death for whatever sordid reason. It leads to destroyed regions of the world, and whole societies may be destroyed, and it may take generations to recover, as it is or will in Sierra Leone. And so I would posit, and I will stop here, is that indifference caused by semantics and definition of what crime it was in and of itself can lead to inaction and certainly injustice.
Thank you, David. Christine?
Thank you, Bill. The same resolution, Resolution 263, which adopted the Genocide Convention, envisioned the creation of a permanent international judicial organ which would hear allegations of crimes against individuals when those allegations were based on charges of genocide, war crimes, and crimes against humanity, or actually at the time genocide and like crimes. It took another 5 decades for the Rome Statute to be signed and for the International Criminal Court to become really on the road to reality. And a decade after that, we are in a situation where the court has been in operation for 5 years. Now, there are many people in the room who were midwives to the birth of the International Criminal Court and could be much more eloquent than I about what the birthing process was and what it represented in terms of an advance in prosecuting genocide and other mass atrocities. I'm here to discuss, just very briefly, as a practitioner, as someone who came in and helped to try to implement the Rome Statute for a brief period of time, what the first years of operation of the International Criminal Court might begin to suggest about the accomplishments in trying to meet the objectives of preventing genocide and other mass atrocities, and also what the operations of the ICC suggest about what the remaining shortcomings are and what the next difficulties may be, what the next generation of difficulties may be. I think to start on the positive side, and it's the kind of field where you do have to stop once in a while and pat yourself on the back for what's been accomplished in it, because it's an important mission and it seems endless sometimes, but there are strides being made. 105 countries have now ratified the Rome Statute, and it's a growing number. 2 of the most recent countries or states to accede to the statute are Mexico and Japan. Japan had long-standing objections to the statute, but it has come aboard now. And what this represents is one of the most basic objectives that's being met, which is to make the international rule of law one that is internalized and made universal. So every one of these countries, when they come on and they ratify the Rome Statute, also agree to make, within their domestic law, to adopt those same standards and to criminalize the same conduct. And this has very, very real implications. In Great Britain, last year or 2 years ago, after they adopted an ICC law, which is called the ICC law, they began prosecutions of their own soldiers for crimes committed in Iraq under that statute. And the significance of it is that one of the ultimate aims is to use every mechanism against genocide, war crimes, and crimes against humanity. And there are victories when domestic prosecutions become more robust, which they are becoming, and when the international rule of law is applied. I would say also, in terms of, there was a discussion this morning about what are the state's obligations. Now, aside from states adopting and undertaking to prevent these mass crimes on their own soil, what the Rome Statute ratification represents is that they will undertake to support the work of the court when the court undertakes, in turn, to prosecute these mass crimes. And so there's a compact being entered, a network being created of support for prosecution of these crimes wherever they occur, when these cases are commenced in the International Criminal Court. So you can see the progress that's being made against the objectives that some of the drafters of the Genocide Convention foresaw or set forth. I think another thing that's worth mentioning in terms of an accomplishment is that the judicial organ is systematically now reviewing, from literally thousands of communications and referrals, any situation that someone cares to write to the prosecutor about and say, hey, this is a mass crime. We'd like somebody to look at it. We'd like somebody to apply legal standards, to apply objective criteria. That process is now underway. And through that process, the prosecutor and the judges have elected to start some investigations and prosecutions and to reject others, for example, in Venezuela and Iraq. So there is the court is acting as a clearinghouse of allegations about mass crimes. And that, I think, is an accomplishment that the ICC represents. I would also say, in terms of prevention, which everybody here has recognized as sort of the ultimate aim, the ICC has in its first cases undertaken really the most difficult circumstance, which is to try to prevent genocide by being involved in the conflicts as they occur. And so in the DRC and in Uganda and in Darfur, we are there investigating and trying to prosecute at the same time that the conflicts are underway. So to whatever extent that involvement can help promote deterrence, we'd like to give ourselves a chance to achieve that and give the international community a chance to achieve that. It's not an easy way to conduct an investigation, but it is, we hope, will turn out to be a fruitful one. And I think Uganda, as Juan Mendez was discussing this morning, is actually an example of deterrence having an effect, because the Lord's Resistance Army leadership did come to the table in part because they perceived a real threat, that there would be accountability, that they would be held to account. Now, let me turn to the negatives, because I think that there are some, and there are some shortcomings. And I think one, I can't talk for very long, so I've sort of reduced it to one shortcoming or difficulty or next generation of problems. I think there's a huge expectations gap about what the ICC can achieve. And I think if I were forced to put it into a sort of one underlying problem, I think that there can be a lot of misunderstanding about what the ICC is going to do and what is the ICC's responsibility, and what remains the responsibility of states and other interested parties, civil society, NGOs, the media, student bodies. Everybody needs to remain active, because one thing that people often forget about the ICC is we are still based in state cooperation. The ICC doesn't have its own arresting force. Every time I went to the field and interviewed somebody, every step that I took represented both things that I was able to get as cooperation, a place to interview, a UN flight to get there, some way to protect my witness, and other forms of cooperation that I was unable to get, some flight I wasn't able to take, some protection mechanism that somebody wasn't able to offer me. And really where the rubber is hitting the road now in terms of the ICC's current cases, and I would like to say a couple of words about Darfur, the ICC now has 6 warrants outstanding, 1 man who's going to trial, and will probably go to trial either later this year or early next year. And of the 6 warrants outstanding, basically we're in a situation where no single person named in an arrest warrant has been arrested and turned over for prosecution by the ICC. And this, I think, represents really a turning point or possible, it's really a threshold that we need to get beyond. If the ICC cannot send out helicopters and arrest people, ultimately it comes back to the same problem that we were discussing this morning, which is where is the political will to bring people to the bar of justice? And the interesting interchange that happened this morning, which is, well, the ICC is timid and too late. And then the response, I think, was correct, which is, well, what did you expect the ICC to do? Here again is that expectations issue. I think, let me put it in a changed and much more negative way. The issue in Darfur right now is no matter what the charges were, no matter who the targets were that would be named by the judges of the ICC, and no matter what label we put on the crime, the Sudanese government has already said they will not turn anybody over to the court and that they will not cooperate in the ICC's investigation. In the face of a UN Security Council resolution that obligates them to cooperate with the court. If that is where the stalemate gets left, then that is a serious moment for international criminal justice and for the prosecution of genocide and other mass crimes. So I think that they're really, as the mechanisms go forward, and all of them are welcome, the hybrid tribunals, there's more than enough work for everybody. What we can see is you can begin to parse more closely how are the mechanisms working. The ICC warrants can be, we are a tool. We are a tool. We're a new actor, but together with the states and the other interested parties, we all need to learn to adjust to one another and use each other effectively as a tool. However, if the tool of arrest is never effectively employed, a lot of the other things that we're talking about become completely hypothetical and irrelevant. Okay, including, you want to talk about aggression at the next conference, which everybody loves as a topic, you can write aggression on a piece of paper, and if no one's going to go out and get your perpetrator, you still have the same problem. So I think it's just a growing experience of watching the institution come into practice and then learning and trying to regenerate understanding amongst the parties and galvanize, use that understanding and action to galvanize more political will, which we've all recognized as the hardest part of the job that we're trying to do. Okay, thank you.
Thanks, right? And you're going to speak perhaps with a translator? I'm not.
I will start as thanks everybody is here and some simple English words and thanks the law school is here. And also try to speak in the beginning a little bit in English, and after that I will switch to the Arabic, and my friend, he will help me, and the translators here, and maybe we can give the full picture about the situation in the Iraqi High Tribunal now, because the morning some people ask me if I can talking about the Iraqi situation now and what the solution. And I told them, I think it's 5 minutes, maybe 15 minutes is not enough to talk about the Iraqi situation. It took now is more than 3-4 years. And also some people like to learn something about the Iraqi judicial system in Iraq, because, and what they're dealing with the laws there and what the laws. And I told them, okay, but I think today we are here for the genocide crime, and we are here for the IHT, and what the prosecution there. As my friend Robert said, our system in Iraq as French system is different about the systems is here, especially the criminal system. That's make some difficulties with the investigation and prosecution. Now I will start to switch to the Arabic language, and my friend just helped me. أنا أشكركم شكرا جزيلا، وأعتقد أنه في الكلام على المحكمة الجنائية العراقية العليا في البداية أعتقد أنه هي نقطة جيدة للبداية الصحيحة في العراق لإرساء فلسفة سيادة القانون. You like to start or switch?
Yeah, talk a little bit more.
Okay. السبب في ذلك أنا أعتقد أنه لو نظرنا إلى تاريخ العراق لوجدنا أن فلسفة التصفية والقتل السريع كانت هي الفلسفة السائدة عندما يتم تغيير أي نظام حكم في العراق، خاصة إذا نظرنا أخذنا بنظر الاعتبار أن نظام الحكم في العراق عندما تأسست كدولة عام 1921 كان ملكي، والدستور الذي وضع في تلك الفترة في عام 25 ويسمى القانون الأساسي أرسى هذا النظام.
Again, I would like to thank you for giving me the chance to be here with you today, and it's good to start with a little bit about the history of Iraq. After the end of World War I and the separation of after the establishment of Iraq as an independent state, the system was a monarchy, and the system faced many revolutions and coups, and eventually it changed into a republic. I think talking about the Iraqi, the higher Iraqi penal court is important, and it's a good start for the establishment of democracy and respect for human rights, especially in Iraq and in the region.
بعد تغيير النظام الملكي في عام 1958 على أثر ثورة عبد الكريم قاسم، قتلت العائلة المالكة في لحظات بعد هذا التغيير، وكذلك الحال حدث في عام 63 عندما قامت الثورة ضد عبد الكريم قاسم، حيث أعدم عبد الكريم قاسم خلال 30 دقيقة في محاكمة سريعة عسكرية، ورمي جثمانه في نهر دجلة حتى لا يكون له قبر في تلك الفترة. لذلك أقول أن البداية تكون صحيحة حتى وإن كانت مجرد نقطة واحدة، لكنها من حيث الناحية القانونية تكون جيدة لطريق مستقبلي أفضل.
So in 1958, the revolution and the coup of Abdul Karim Qasim, who led this coup against the monarchy, and it's interesting enough that the whole royal family were killed instantly. In 1963, when there was another coup against Abdul Karim Qasim himself, he was killed in 30 minutes in a trial that took 30 minutes, and his body was thrown in the Tigris River so that there would be no gravesite for him. So, as you see from looking at the history of Iraq, the change of systems always, was dealt with violence, and that's why we look at the establishment of the court now, although it's just a small beginning, but it was very important to start on the correct path by establishing the law and the democratic way of changing systems.
أما بخصوص الصعوبات التي رافقت العملية التحقيقية في هذه المحكمة، فحقيقة كما ذكر كثير الأخ الزميل روبرت هنا أنه النظام القانوني ليس من السهل في العراق تطبيقه واستخدامه في مثل هذه الجرائم، لكن وجود قانون المحكمة الجنائية العراقية العليا الذي بدوره عكس حالة التطور القانوني، ووجود أيضا قانون أصول المحاكمات الجزائية العراقي، استطعنا من خلال العملية التحقيقية أن نوجد نوع من التمازج والتكامل التحقيقي بين هذين القانونين للمضي قدما في إنجاز التحقيقات. وقد واجهتنا مجموعة صعوبات. أهم هذه الصعوبات أنه الفترة الزمنية الطويلة التي استغرقت سلطة المحكمة هي من عام 1968 إلى عام 2003، وكثرة الجرائم المرتكبة ووجود آلاف الوثائق. لم أكن مجانبا الصواب إذا قلت أطنان من الوثائق لا بد من تدقيقها والمرور خلالها لإيجاد الدليل من خلال هذه الوثائق.
As we mentioned earlier, and he referred to his colleague Robert, concerning the difficulty in applying the law in Iraq, especially with the differences in the legal systems, and he talked about the presence of the French legal system in Iraq in the beginning. But the establishment of the higher Iraqi penal court was a sign of the progress that the legal system have passed through in Iraq in the recent in the current time. And then he talked about some of the difficulties that have faced them in dealing with the cases that were brought to the court. We are talking about a period of time that spanned from 1968 to 2003. It's a long period, and a lot of crimes, which means a lot of documents that you need to look over and check and document, and try to extract from these thousands of documents proofs for the crimes that have been committed.
ولكن في نفس الوقت كان لذلك الاتجاه أو ذلك الأمر جانب إيجابي أيضا، وهو أن جعل التحقيقات تكون أكثر سهولة من خلال أنه جميع الأطراف أو عناصر التحقيق موجودة في مكان واحد وهو في العراق. لذلك فكنا من خلال هذه التحقيقات ننظر إلى العناصر الرئيسية التي تساعد في تحديد التكييف القانوني للوصول إلى الوصف القانوني الصحيح للجريمة المرتكبة، وتحديد هذه العناصر من خلال شهادات الشهود والوثائق المستخدمة وسلسلة الأوامر وأسباب الاستهداف إلى المجموعات السكانية، وهل هذه المجموعات السكانية هي عناصر محاربة أم عناصر مدنية، ومراعين في ذلك الوقت الظرف الاقتصادي والسياسة الاقتصادية والسياسة العامة للنظام اتجاه هذه المجموعة.
Now he talked about the investigative process for reaching the crime elements, and he mentioned that the presence of the members of the investigating team at the crime scenes and their full residence there have helped in lessening the difficulties that he started talking about in the beginning that were associated with the investigations, especially that everyone involved with the investigative process lived in and resided in Iraq. For that, there was a great emphasis on the professional side with no time pressure. The main task was to find the common and relative factors in the chain of orders, starting from the highest ranking chief to the lowest ranking one. And like, for example, we would look at certain investigative elements, like the order coming from the highest ranking chief, the reasons behind that, the goals behind this, and to which group this order is being directed. Which group is being targeted by these kind of orders, and are these groups civil groups or militant groups? And then we investigate the reasons for such groups being targeted, and are these reasons religious, ethnic, racial, or nationalistic? Also stressing on the nature of the given orders as it relates to the time factor. Also talked about the human factor, the geo-religional factor, and how clear and explicit the orders that were coming from the highest ranking chief.
وسوف أختصر الوقت حتى لا أخذ من وقت زملائي وأركز على أهم ما برز في التحقيق. الأهم نقطة كانت برزت لنا هي الحقائق التي كشفت من خلال العثور على المقابر الجماعية وقتل الآلاف من قبل النظام، سواء كان عربا أو كردا، من خلال سلسلة الهجمات المنظمة التي ارتكبها النظام تجاه هذه المجموعات السكانية. كذلك النقطة الأخرى التي أعتقد أنها كان لها دور إيجابي في المجتمع هي أنه المحكمة كانت أو عملت على بعض الشيء على تطوير المفهوم القانوني داخل المجتمع العراقي من خلال توضيح حقوق الإنسان وتوضيح حقوق المتهمين وحقوق الدفاع وإعطاء هذه الصورة الكاملة إلى المجتمع، إضافة إلى إرسال رسالة صحيحة بأن فلسفة القانون هي التي يجب أن تسود في المجتمع بدل من فلسفة القتل وفلسفة الثأر. ولو جزئيا نحاول أنه عملت المحكمة على التخلص من فلسفة الثأر في المجتمع العراقي.
Because of the short, the limited time that I have, I'm going to briefly discuss the most important outcomes of the investigations that we were involved with. The first and most important was the ability to find the truth behind some of the committed crimes. By finding these mass graves, checking about the true number of people died in the thousands, trying to know why certain groups, whether they were Kurds or Arabs, that have been targeted, and the reasons behind that, trying to look at the orders that were given, again, from the highest ranking chief to the lowest ranking one. So the reasons behind the crimes was a very important factor that we were able to find as the investigation was going on. The second thing is that our ability to modernize and bring forward a new understanding of law in the land, in Iraq, through the live coverage of the court procedures and how people were following this kind of coverage. They saw how the court functioned, how the defendants were treated, how witnesses were presented forward. So this were like a new education for the society. Also, we were sending a message that from now on, law is going to be established, that no more we are going to go back to the rational killing and to the concept of revenge. Now, I'm not trying to say that we were able to eliminate the concept of revenge or the rational killing, but we were able to partially eliminate this kind of this. He stressed on the issue of this revenge, that you take your right with your own hand.
And also I want to add another thing. I think maybe some people is agree with me or not, but I think in Iraq it's good to start. It's better from don't start. And we are starting in this court. I think that is good for the Iraqi people in the future, and also for all the humanity in the future also. And also I want to say something. The calendar is here. I think is little mistake. Is not mistake. Is the second here. Second one. Is the crime about the Arab march. It's not al-ahwaz. He said al-ahwaz is al-ahwar is mean in Arabic is march.
So I got it wrong.
Yeah, it's okay. Al-ahwar. Just that because I think maybe somebody is when he's read this, he said, what are the ahwaz? This is. Yeah. And also al-ahwaz is area in Iran. This is that is very important. Yes, this is area in the border between Iraq and Iran, and many Iraqi people is living there, and many Iranian people also had relatives there. But this case is Marsh Arab case. Thank you so much.
I was going to start a war between Iraq and
You're fired. Thank you very much, Robert.
Okay.
Can I use this? Or?
Yeah.
Okay. Well, anyways, I'm sure most people are tired by now hearing my voice, so I'm going to be a bit brief, and actually I'm going to start maybe the tone of the panel by respectfully disagreeing with my former boss, David, on this issue of genocide. And I think it actually matters a great deal if you can call it genocide, if you're a prosecutor. Now, as I'm sure most of you figured out by now, I'm not an academic. I'm a simple practitioner. But I think we as practitioners, we're at the forefront of this debate over the qualification of it and what it means for the victims. I mean, civil society, academics, media, they've done a great job in blurring the line between the moral definition and the legal definition of it. David is right, and the other panelists have alluded it to. For the great majority of people outside of these learned walls, any mass murder is genocide now. And you're the one, as a prosecutor, who have to explain, as Eric quite rightly pointed out, the intricacy and the difficulties that you face in being able, if you're making the only decision you're hired to be making, which is a legal one, to charge genocide or not. Do you have the elements or not? But once you get outside of your office and you start talking to the people, it doesn't matter what you can say about intent. It doesn't matter, mens rea is just another, probably something you can order on the menu. What it means to them is that the first reaction you get is that it's somehow lessening what happened to them. Now, the repercussions of your decision can be quite stark and quite significant. But in actual fact, I mean, as a prosecutor, one of the first things you learn in a national jurisdiction or an international one of the hardest part of your job is to be able to explain the decisions you made not to do something. And it's also one of the hardest ones to learn is how to explain to victims of crimes why they don't have any sense of justice once they get out of that courtroom. And again, it goes from you're single victim of a crime in a national jurisdiction to the survivors of mass murders. You got to be able, if you're going to take this job, you got to be able to make those decisions in the first place, and then you got to be able, in the second place, to explain to them, to the victims, to the people. David used to say that Sierra Leoneans were his clients. I'm not that comfortable with that, but at least to the people for whom this matters. Why you did what you did. And then thirdly, you got to be able to live with the fact that you're not going to convince them, or they're not going to be satisfied with your explanation in oftentimes, okay? Just as it is very hard to see to deal with the reaction of a mother when you're coming out of a court where the judge says, no, your 7-year-old was not abused, or I cannot convict, rather, the guy that she knows did it. Just as it is very hard to explain to people that what they've suffered or what their family suffered does not amount to what now most people equate with the greatest of crime, the crime of crimes. We're facing that in Cambodia in a very stark way. And we're going to have to be able to deal with this. And prosecutors are, as I said, the first one everybody looks to, or down to explain why this isn't genocide. And in that debate, you have to be able to explain, and that's why I think I differ a bit, you have to be able to explain why it should matter that it is not genocide, why it is extremely fundamental to be able to, when somebody is found guilty of genocide, to be able to say that all the elements were met and he did have the intent to kill or to destroy just because of the fact that somebody was born into a group or was who he was. To me, there is no greatest crime than wanting to kill someone just because of who he or she is. So I think it's extremely important that if you feel that you have the elements, you should charge genocide. On the other hand, maybe, and that's one of the questions I proposed for the panel, is that maybe as a prosecutor, because of that moral implication that everybody is using, maybe we should push the envelope. Maybe we should try and see if we cannot, even if we're not absolutely convinced that legally speaking we have all the elements beyond a reasonable doubt, maybe we should try and push the envelope and see how the law can evolve. Okay? But then you're faced with a verdict that you're going to have to also be able to explain. And there is a very important dimension to these verdicts. As some of you may know, my wife is Rwandan, and her family obviously suffered. And you can imagine the debates we had when I was working for ICTR and trying to explain why the court mattered at that time. But the fact that there was eventually a finding of genocide, and that there was now a judicial recognition of genocide in Rwanda against Tutsis, matters a great deal to the survivors. Because again, genocide is now associated with the greatest of crime. So that to recognize that your group was targeted for the simple reason of who you are matters a great deal to survivors, to victims. So I think we have to keep in mind, and we have to keep the emphasis on what genocide represents, what it must represent when we do our jobs.
Thank you. I'm going to start actually by polling our panel. We have a quite remarkable array of countries and conflicts represented here. How many of you have worked or are working for a tribunal that has actually charged genocide? I'm going to take the people who didn't raise their hand. David, why did you not charge genocide in Sierra Leone?
Because they didn't give me the authority to do it. It really wasn't a genocidal situation in Sierra Leone. It was a different set of crimes. Certainly crimes against humanity and war crimes stemming from a 10-year civil war, but it was not a genocidal situation. So my statute said that was not a list of crimes I could charge.
And even if it had been on the statute, the facts would not have merited it, probably.
No, not the facts as they were.
Christine, Uganda, probably the facts don't merit it. In Congo, I could probably come up with some facts that merit it. Why has the ICC not charged genocide in any of its cases?
The answer is going to be the same for any prosecutor you ask. You go where the facts lead you and to what you believe you can prove beyond a reasonable doubt, which are 4 words that have not been said yet in this conversation. So you take an enormous responsibility. And I think as, you know, in Darfur and Congo, we continue to investigate. So who knows what the future will bring. But in the situation we were in, at the time we were in, we were not willing to undertake that enormous responsibility based on the state of the evidence that we had. I think every situation is different. For me, I would say that the victims that I've met, the big toggle switches between accountability or no accountability. And if you bring any accountability on the basis of whatever label, you're getting them 90% of the way there. And we can sit in a room and talk about whether persecution amounts to genocide, whether you need dolus eventualis or something more than that, but this debate to the victims that I've met, and it could be very different in Cambodia or any other situation, I don't think that debate is advancing them that much further. I think the other thing about the ICC that's unique, I'm not being paid right now to be at the fringes. I'm being paid right now to be in the core of my responsibility, in the core of my mandate, and to demonstrate credibility. So those stretches can be made and maybe will be made when the evidence is there and there's more room to do it. But right now I think that there are additional considerations.
So, I mean, clearly the challenge of, being able to prove the evidence beyond a reasonable doubt, and we heard from Eric that part of that evidence is a mental intent. Can I turn down to the far end to Cambodia for a minute? Yes, that would be you. You can't hide. How do you go about proving the mental intent element of genocide in either Cambodia or Rwanda, both of which are places you've had experience?
Well, some people make it easy for you by, for years and years, qualifying a group of people as something less than human, as was the case in Rwanda. So, I mean, I still remember one of the earliest debate we had, though, when some of our colleagues, especially African colleagues, were saying that, yeah, but we can't charge genocide because the Tutsis are not really a racial group. They're not different from the Hutus. And we had to have the debate of it doesn't matter what empirically they might be. All that matters is that the guy who's killing him believes it. So, like I said, in some cases it's easier. Others, as is, for example, in Cambodia, you do have to try and find the intent through different means. You may have, again, intent clearly shown by speeches or by incitement. You may have a system of discrimination that gets built over time, and that makes for a very circumstantially strong evidence of intent. But again, you may also have to face the fact that you will not, for certain groups, find that evidence or find that intent. I mean, it might be true that, for example, again, coming back to Sierra Leone, as a whole, the conflict could not qualify as genocide. We never know, but we may have missed a couple of individuals who locally, based on tribal lines, for example, could have fit the profile had we the jurisdiction. Same as in Cambodia. The statute allows us for certain groups, might not be applicable to the Cambodian population as a whole, but we might have cases that apply to single groups, which will make my job a lot harder if I have to tell the Cambodians people why their killings is not genocide, but the other groups is.
I think all of the courts that you have worked for have faced pressures externally related both to funding and to the speed at which they operate. And one of the things that I think we've just heard is that proving genocide can be hard, it can take a long time, it can require finding evidence that goes beyond forensic evidence from the actual crime. How do you deal with that as a prosecutor? Do you think about the fact that whether it's the Assembly of States Parties or the donors or the Security Council has said complete your work by such and such a date and make sure you don't spend more than $100 million a year if you're the ICTY or $20 million if you're perhaps one of the hybrid tribunals? Do you take that into consideration when deciding what charges to bring, or do you try to prove genocide because, as it's been described here, it is often seen as the crime of crimes? Anyone who wants to take that should feel free. Yeah, right. Let me start with Raid, and then I'll come to you, David.
I will say something about this, is special with the professional job. It's different, it's separate difference, it's complete difference between the academic theories and the professional job. And when you are explaining to our people in the academic way, I can about the theory and the elements, or I can select the elements and put the elements in the crime. But in fact, when you have a crime in the land, and also you have elements for this crime, should we select these elements one by one, and you can check how we can what the line between each crime, especially with the local or international law. This is many challenges for the prosecutor or the investigation judge when he is give the exact article, exact charge. This is especially with the, sometime in the local, in the domestic law, you can find many cases, one next one, and many crimes also, one next one, and which exact article. That's up to the elements. Not for the personal theory, not for the opinion, personal opinion, no. That should be follow the law one by one, and after that we can thinking how many documents he found which the order clear or not from the commander or from the person is in charge with this is a group, and what the reason behind this is the crime, and how they are doing this crime. And I think maybe, I'm sorry, maybe my language is not enough to explain this, but I think the elements give you all the guide line to select the article or the charging exactly. It's not your opinion or your theory. No, especially with as a prosecutor or as a judge. Mm-hmm. This is because this is your responsibility.
So be guided by the evidence and follow it.
Yeah.
David, was that your answer as well, or did you have a different take on that?
Well, no, I couldn't agree with the judge more as far as you have to do your job and do your job ethically and do the best you can. But when you're talking about funding, you're talking really about politics. You know, we all understand that all of these tribunals, in whatever form or shape that they've come from Nuremberg all the way forward, they're creatures of political events. They are creatures of political compromise, and that's how its mandate is formed and shaped. I happen to have a fairly decent mandate, and that was prosecute those who bear the greatest responsibility. It's the first time that that's ever been used before in history. And so I had to make some pretty tough decisions, and Robert and I had many round tables as to who bears the greatest responsibility. We had national monsters, and we certainly had regional monsters, and there were certainly regional monsters that certainly could have been prosecuted for war crimes and crimes against humanity, but I had to make the difficult decision that that they weren't greatest responsibility, and also factoring in, because it's a naive prosecutor who does not factor in politics, that I can't prosecute everybody in the world. I was limiting it to as few as possible that I thought bore the greatest responsibility. So that's an answer, but same thing with Charles Taylor. There was two other heads of state culpable that certainly arguably could have been prosecuted, and I chose not to prosecute them because of the political blowback, which would have largely ended the court. There are certain nations of the world who would have pulled the rug out completely and would have probably flushed the whole thing down. So anyway, that's just a perspective that I had.
Christine?
And maybe to add a fact that people may not know, our budgeting is based, we go to the Assembly of State Parties and we tell them how many situations and how many cases we expect to have. And so they get what they pay for. And the prosecutor and the judges have told the ASP at different points, if you want more cases and you want more situations, then you need to make the corresponding adjustments in the budget. But I think in terms of the drama of the question, I think there's pretty much consensus across the tribunals, the ad hoc, and the hybrids now that you were looking for maximum impact with minimal resources. That's the mandate that's been given to all of us, and it's a lesson that maybe has been learned in some hard ways, but that's what people want and that's what they deserve.
So if you do not bring a genocide charge in a particular situation, either because the evidence doesn't merit it or because it may be too difficult to prove, how do you go about communicating to the populations in those countries the decisions and the reasons that lie behind those decisions? It's fairly easy for us to cite to the particular parts of the Genocide Convention and say, we can't prove the mens rea of an intent to destroy in whole or in part, so we'll get somebody on a crimes against humanity charge. But when you're actually in the field, how do you reach out to communities to get them to understand and react to that? We'll start there and then come down to Eric.
That's one of my main things. I was going to say Oprah, but that's probably not going to work. You need outreach, first of all, I think. You need to be able to understand, obviously, your case. You need to be able to communicate at the level of your audience. But you need to be able to convey, first of all, the most important message. If this person was not charged for genocide, it does not mean that what happened to you is not important. It does not mean that what happened was not of the gravest import. What it means is that legally we couldn't sustain the process. And you can only do that, or your best chance of doing it is through outreach. It's not through the media. It's not through the government. It's not through civil society. It's by going and talking directly to the people. One of the biggest failing ICTR had is from the beginning there was no thought to outreach at all. It allowed what was happening in another country to be distorted by civil society, by the media, by the government. We lost that one way early on. One of the best things about Sierra Leone was that, again, the lessons were learned. You had people at the end of the week of court hearings taking, extracts on a video cassette, a TV, a generator, getting on the helicopter and going in the bush, and then calling everybody over in the village, showing them what happened, and then answering their questions directly. So I think, to me, the credibility of the whole court, your whole process, but most especially those decisions about those charging decisions, rests on your ability to talk directly to the people in a way that they can understand what your decision was.
Eric?
I would concur, and I would like to sort of tie this point into a couple of the earlier points, which I wanted to address earlier, which is outreach is critically important because so much of the populations in which you're talking to do not understand that distinction between what constitutes genocide as a legal matter and what is mass murder. Now, drawing on Robert's point, from the victim's perspective, just because something does not constitute genocide, it doesn't mean that it's any less bad to them. Now, critically, what that means, and ultimately one of the biggest failings, I think, of the High Tribunal was we didn't learn from the lessons of the ICTR. In other words, there wasn't necessarily a credible outreach program from the beginning. And although, yes, the court aired gavel to gavel all of the coverage, that's not enough. Simply watching trial proceedings unfold without people going out into the field and explaining what it is to prove the intent. You asked the question earlier, how do you prove the intent? You go out and you cull through the documentary evidence, you cull the mass grave evidence to sit there and determine where are they physically located in relation to the individual victims' homes, such that they were transported there and across large distances, such that you might be able to demonstrate circumstantially that someone tried to target them specifically for their racial group. And again, going out and being able to combine all of these different elements so the individual victims and politicians as well understand better why it is that the court is functioning and how it is functioning goes a long way to buttress any of these tribunals from the political charges at stake. But make no mistake about it, as a prosecutor or a judge, you don't have any ability to play with regard to those elements, and you shouldn't. At most, maybe if there is some gray area as a prosecutor, you may decide to bring a charge of genocide. If you have a good faith basis to believe you can prove this beyond a reasonable doubt, but maybe if you have a little bit of doubt, then you're not beyond a reasonable bit of doubt. So maybe you'll leave it to the judges themselves to make that ultimate determination, because you know just as much as everyone, as my colleague over here said, if you completely divorce yourself from the political spectrum, then ultimately you might lead to repercussions to your tribunal which you didn't necessarily foresee to begin with. And those repercussions could be negative, such as defunding, naked political interference, or others.
I want to get to audience questions, but before I do that, I'm going to pose one question to everyone on the panel, hoping that you will give me a very brief answer to it. And I'm framing it in a way that you should be able to. You have all worked with either the Genocide Convention or the definition of genocide framed in the statutes of particular tribunals. My question for you is, was it properly drawn, properly constructed? Did it give you the tools you needed to bring the charges that you wanted to bring? Or if you were to revise the convention, what would you do differently? I have silence. Robert.
I'll start. My life would be much simpler if political group had been included.
Yep.
And I think it would be a much better statute.
I didn't have to, so I'll pass.
I'll pick up one on Christine's point earlier about apprehension. Should there be a special duty for apprehension in cases of genocide? Because there may be a special duty in the convention to prevent it. Does that mean that states ought to have some higher duty in terms of apprehension? Robert's shaking his head no.
They all deserve to be tried. So.
Yeah. Let me throw the floor open to audience questions. Michael, I'll start with you since you get the organizer's prerogative.
I'd like, because this is really extraordinary to have Judge Rod making his first public appearance at an academic conference in the United States, and thank you for coming. Can I ask you a human interest question that may not be directly related to the technical aspects of prosecuting genocide, but we all saw you on TV when Saddam Hussein was first arraigned. You were the brave judge who had his face, or at least half of your head, shown on television, dealing with Saddam Hussein, the former leader, and telling him what the charges against him was. Can you just give us your impressions of what that was like?
Thank you, Mike, for this. Is in the beginning, the not face is the famous bag I had. Because some TV, I think, just took the bag, and some TV took the face. This is a very good question. I'm already a judge under Saddam regime. I'm working as an investigation judge in Najaf before. That's before 2003. And we believe the rule of the law should be is control the country when we can. And when the regime is gone and start a new country, we try to really catch this is word, and we think we are judges. This is our responsibility because we are legal persons. We are try to use the law in the country. One from the good message to the Iraqi people, special, and that time, they think is no rule, no legal in Iraq, and nobody can is talking with the government, ex-government, is a new government, and that's. And when the Chief Justice and the government select me, this is mission. Many people talk about this is issue. it's public or not public, but the public is very important to Iraqi people. And as a judges, this is our job. We said in Iraq that the difficulties job is judge's job, because you don't know which case you can in charge of this case. And the first question I remember, and I think is Eric also is remember, my colleagues is asking me if you like the public, and yes, we are public, because all the Iraqi people is looking about this is time, and all the Iraqi people is looking for the making new justice in Iraq. One from our responsibility to give this message to Iraqi people is they thinking about the new justice coming to Iraq. At least we are start with the first hearing with ex-regime and with Saddam Hussein and other ex-regime. My responsibility in that time, I think this is my job, and I have to do that because this is my responsibility and my duty for my society.
Yeah, John. I think there's a microphone coming for you for the webcast purposes.
John, quickly. I think the panel hit on a very key issue of whether to be more conservative in the approach to prosecution or whether to be more expansive. And it seems to me that is a really critical question, particularly in the prosecutions that are being done under national law by some kind of national or hybrid tribunal. And I think with regard to the Cambodia prosecutions now, apparently the idea is to prosecute for war crimes, for crimes against humanity, perhaps for genocide, in addition to perhaps under the murder provision in the Cambodian Penal Code. One problem with this is that in the Cambodian Penal Code, one does not find an offense of genocide. One does not find an offense of war crimes. One does not find an offense of crimes against humanity. Nonetheless, these are going to be charged. The same problem existed in Iraq. In the Iraqi Penal Code, there was no crime of genocide. There was no crime of crimes against humanity. There was no crime of war crimes. And in fact, in the Iraqi Penal Code, there is a specific provision saying that no act can be prosecuted unless defined in this code. Now, I think on the Cambodia side, with the war crimes charge, there's an additional problem in that it's not very clear that there was a war going on during that time period. Vietnam didn't come in until the very end of December of 1978. I mean, so to charge war crimes on the theory that there was a war going on is obviously going to open the prosecution to challenge from the defense. On genocide, as Robert has mentioned, there's the issue of whether one can charge genocide when the victims are of the same group, apart from the question of genocide against some groups in Cambodia that were different in terms of religion or in terms of ethnicity. I mean, my own view on that is that there would be a basis for charging genocide. Robert mentioned that I was involved in the 1979 trial of Pol Pot in Phnom Penh, and my role was expert witness on the law of genocide. And I gave an opinion to the court on the law of genocide, and I said that I thought that the facts constituted genocide because the way I read the Genocide Convention, there's no requirement that the people that you go after be different from your own group. Now, however, most people, I think, who have analyzed that take the other point of view. I mean, most analysts say that you've got to hate the people and you can't hate your own people. I don't find the word hate in the Genocide Convention. But the fact that that is so controversial, I think, militates perhaps against using that. So, I mean, I'm wondering if a more conservative approach on these matters might be better. I understand the pressures, both in terms of the public, trying to explain to the public, and then also...
So the question I've got really is about how conservatively or broadly to interpret the convention, particularly in light of the Cambodia examples.
And in particular, in the jurisdictional sense, that is, why charge crimes over which you don't
So what I'd like to do is ask the audience, the panel, to jot down a response. I'm going to take about 2 or 3 questions from the audience and then give the panel a chance to respond to all of them so that we can have multiple questions. Let me go to the gentleman behind in the blue sweater. No, I was, well, you were a black sweater, sorry. That black, all right. Go briefly, I'll take both of you.
I'm going to ask a question, not make a speech. I know nothing about this area of the law, but it's my understanding Mr. Crane is saying that it really doesn't make a difference whether it's a person charged with genocide or crimes against humanity. I think you used the term, so what? Am I correct that this is your interpretation, my interpretation of you, and does any member of the panel disagree with this concept?
So does it really matter if you charge genocide versus some other set of international crimes? Yes.
So all of you have talked about how you are operating in a politically constrained environment. And I've just started law school, so when you say genocide to me, I don't know, I have no way to relate to what that actually means. And it seems like if you're looking to extend the political world in which you're operating, you need to explain to people that are not subject to genocide how it works. How do you do that, build political support for what you're doing to people that have no basis of understanding?
So how do you explain what genocide really means to people, and how do we understand what it really means? Professor Sadat?
I had a quick question because I thought I heard some contradictory statements. I thought I heard many of the panelists say that no matter what the particular elements of the activity, the mass atrocity, whether it be killing, torture, mutilation, rape, destruction of property, was horrendous and terrible. And from the victim perspective, it really didn't matter what the legal qualification was. And then I thought I heard them say, at the same time, we believe, right? And I think, Robert, you actually said this, that genocide is actually the crime of crimes. And so my question to the prosecutors and to the legal scholars who argue that genocide is, quote, the crime of crimes, is how can they reconcile their view and their espousal of genocide as the crime of crimes, and at the same time telling victims who are the victim of other crimes, well, your crimes really are as important, they're just not quite. I guess I'm just hearing some contradiction.
Is genocide the crime of crimes or not? Roy, you'll get the last word before I go back to the panel.
I don't mean this facetiously, but would any of you bring a case before the ICJ charging genocide, or put it another way, what went wrong in the case that the Bosnians brought?
The last question, I will say we do have a session on that at the end, so hopefully we'll get more on that question. Let me go back to the panel. Eric, shall we start with you and walk down the panel responding to any and all of the items on the table?
Well, we don't have much time here, so I'll just respond to the second question. I'll leave the others. I can talk for a long time on each. I firmly believe, as Robert said, that genocide does matter. It matters to the victims, it matters to the politicians, and most importantly, as a prosecutor, it matters to you as a lawyer. And if you don't keep that distinction in mind and you don't understand the contours of what that crimes mean, you're not going to be able to do your job properly. Now, understanding the legal distinctions between genocide, a crime against humanity, and a war crime, and making the charging distinction is very important from where I sit. However, the public outreach program in any single one of these tribunals, and you as a prosecutor going out and speaking to those victims, must make clear how you deal with them on a one-to-one basis. They have suffered. You acknowledge why they have suffered, how they have suffered. These perpetrators are being brought to the bar of justice, and just because international law may recognize genocide as the mother of all crimes, it does not mean that because you're charging crime against humanity, which may be a half step down, that somehow their suffering is any less. It's a very difficult line to balance, but you must be able to walk that line, or you shouldn't be in this line of business.
David.
My point as far as so what is that in reality, yes, there are various crimes. I was looking at it more from a public point of view. My mind is dead, and So that was what I was saying about so what, and my point in my opening remarks is that the international community, not scholars or not people who are up on this, don't make this distinction as far as, well, they do make the distinction. If they hear genocide, it's much more important, therefore they may act a little bit more specifically. If it's not genocide, that means it may be something less, and therefore we've got other fish to fry, we've got plenty of other problems in the world, and they may move on because that's exactly what happened in West Africa. And so I was just making that point. We have to be careful semantically, but certainly if the facts show that, and you have the mandate that allows you to do it, certainly you prosecute to the maximum extent of the law, following facts and law. But my point was, in my opening remarks, was that we have to be careful and understand that right now, even the problem with just genocide itself, the world is stepping beyond it. It's still a political act, and it drives the train. And regardless of whether it's a genocide or a crime against humanity, if there's no political will to do something about it, it just won't happen. And that's a perfect example is Darfur and other places.
Christine?
Yeah, I don't think anyone's disputing that as a legal matter or as a matter of ability to trigger a reaction, genocide is the crime of crimes. I think the point we're making is if you're in the prosecutor's chair and you have a way to maybe achieve the same punishment with a lesser charge, and what you would acknowledge as a matter of the elements is a lesser charge, and the trade-off might be that if you charge genocide, you're going to be stuck in trial for another year. You buy the risk that the judges are going to tell you, sorry, I disagree with you, it's not a genocide. Or you have to endanger and relocate 40 more witnesses to make that additional charge. You're looking at some pretty hard decisions. And that's our reality. That's just our reality. And so I go back to the point, I think countering impunity is the first basic step. Let's get the accountability and the punishment in there. If you have a second case that can be on file that's about genocide, that's great. If you can bring the additional charges without bringing those downsides, you should do it. But these are the calculuses that we undertake, I think, every day.
Right.
I think if you are, anyone is working with the tribunal, he can find there's many difficulties. As some of the difficulties is politics difficulties, especially in the trial and the courts inside the same country, and also you can find this is professional difficulties and a lot of pressure. And but the big challenges is for each one if we make a charging is genocide or crime against humanity, it should be dealing with the evidence. What I said in the beginning, the evidence we say the evidence is talking. Evidence, just the evidence. If you're dealing with the politics and he's worried about his job, and worried about maybe the politics is agree or not, 100% he will go to the wrong way. For that, I think this should be the big challenge for each one is working for. This is any trial like this should be in charge 100% with the legal way. That's it.
Robert?
And when all else fails, blame the defense.
They're on next.
I know, that's why it's a good segue. As I said, I mean, Leila, there's no contradiction. I mean, to me anyways, it is the crime of crimes and necessitate the strictest of interpretation, and you have to be able to back it up. There are realities, there are judgment calls you make every day in this business, which is very easy to criticize, but which we have to make and then be able to explain. You don't tell the victims, oh no, you were just a victim of a crime against humanity, it's a lesser problem. You don't.
No, that's not what I said.
No. No, what you say, what you tell them is that they didn't kill your mother because she was a Tutsi. They killed her because they wanted to take and keep power. And that's a different legal qualification, and that's why I have to charge it as I did. You explain to people what the law is, if you can, in the most normal terms. What else would you have us do, Leila?
I'm going to have to let you take that debate to the hallway while it's an important one. Let me say thank you, Eric, David, Christine, Raid, and Robert. Merci.